the constitutional right to bear arms has outlived its usefulness. Now, one reason I relish this statement of the question is that I'm one of those relatively rare people, I will admit, who actually believe there should be a new constitutional convention, because I believe that a number of provisions of the Constitution have outlived their usefulness. I wouldn't even say that the Second Amendment or the right to bear arms is the one that has most outlived its usefulness, but I'm really quite happy to argue that in 2013, the kinds of considerations that led to the placement of the Second Amendment in the Bill of Rights, which Bob Rosencrantz summarized, I think, very well, have outlived their usefulness. So if we were going to have a debate in 2013 about what substantive rights, as well as what structures, the Senate, bicameralism, presidential veto, and stuff like that, what would a 2013 or 2015 Constitution look like? Would it include a substantive right in the United States Constitution to bear arms? And I would argue that the answer is no. Let me also emphasize that this is a different question from whether state constitutions should include a right to bear arms. Eugene has written one of the definitive articles showing, I don't know what the current number is, but I think it's over 40 state constitutions do protect a right to bear arms. And that raises a very, very important question of whether we need to have that in the United States Constitution as well. Let me give you two principal reasons why a constitutionalized right to bear arms, instead of a right to bear arms that would simply be fought out in the political process, and all of us know that the political process today is tilted either legitimately or illegitimately. That's the topic of yet another debate that we need not have this evening, generally in favor of the rights of gun owners. So let me give you the two reasons why I think the Second Amendment has outlived its usefulness in the 21st century. The first reason is precisely that it is anti-federal. That is to say, one of the anomalies, sometimes it's very difficult to tell the players without a scorecard in the debate about gun rights. There are many, many people who define themselves as conservatives who rail against a rampaging national government that believes in one-size-fits-all solutions to national problems. Well, this is not necessarily what Heller decides, but it is what the Supreme Court decided 2 years later in the McDonald case, where it held that every state in the Union has to toe a single line. Louis Brandeis spoke very eloquently of states as little laboratories of experimentation. Most states have chosen to experiment in favor of gun rights. There are some states or cities, very dense cities like Washington, D.C., that would prefer different experiments. Or in New York itself, one can well imagine a particular policy for the great cities of New York and a very different policy for upstate New York, where there are far, far more hunters than is the case in Manhattan, say. And one of the things that a single national constitutional amendment, as interpreted by the Supreme Court, does is to stifle that kind of federalism, and I think that's a mistake. But there's a second real problem with constitutionalizing the right to bear arms in the 21st century. As Mr. Rosencrantz suggested, the right to bear arms, or the Second Amendment, had a kind of cosmetic value until 2008. It's not that people didn't write about it. I wrote about it. Eugene wrote about it. A number of people found it very interesting. But it played remarkably little role in actual American law. Beginning with Heller, it does play a role. But what does that mean? It means that you turn over decision-making power to a group of federal judges who are highly divided, who have no expertise in this area, and who make often quite remarkable, even unreasoned distinctions. Thus, for example, in Heller, Justice Scalia says that Dick Heller is protected, which I think is a perfectly plausible argument, but he suggests that Martha Stewart is not, because she actually lied to an FBI agent and is thus a convicted felon. I don't think judges should be making those kinds of decisions. I think legislators should.
Thank you, Sandy Levinson.